Keep in mind, the ultimate reason for an arrest warrant in Texas is to bring a person before a magistrate. In most situations, a person arrested on a warrant is taken by the peace officer directly to jail. This is done in order to secure their appearance before the magistrate at some point following the arrest, since it would be impractical to expect the magistrate and the rest of the courtroom working group to respond at odd hours of the day or night and hold court for each and every defendant who was placed in custody by means of a warrant execution. Since the magistrate acts as a check and balance on police power, the Code of Criminal Procedure lays out some very specific requirements once an arrest on warrant has occurred to ensure a defendant is promptly delivered to the magistrate. According to the Code of Criminal Procedure, in each case of making an arrest, the person making the arrest or having custody of the defendant shall, without unnecessary delay, but not later than 48 hours after the arrest, take the person before a magistrate of the county where the arrest occurred. To provide more expeditiously to the person arrested his or her magistrate warnings, he or she may be taken before a magistrate in another county. To help facilitate this, the Code of Criminal Procedure states closed-circuit television systems may be used. This is a very important concept. Remember, taking a defendant to jail following an arrest, including an arrest under warrant, is not intended to be punishment. It is to secure the defendant's appearance in court before a magistrate. To this end, without exception, a defendant must see a magistrate without unnecessary delay, but no later than 48 hours after arrest. During this appearance, the magistrate shall inform in clear language the accusation against the defendant, the right to retain counsel, the right to remain silent, the right to have an attorney present during any interview with agents of the state, the right to terminate any such interview at any time, and how to request counsel be appointed if indigent. If the defendant is deaf or hard of hearing or does not speak or understand English, the magistrate shall inform the defendant of his or her rights through an appointed and sworn interpreter. The magistrate shall ensure reasonable assistance in completing necessary forms for requesting appointment of counsel. If the magistrate finds a defendant indigent and is authorized to appoint counsel, he or she shall do so at the time of the defendant's appearance. If the magistrate finds a defendant is indigent but is not authorized to appoint counsel, he or she shall forward the defendant's application for counsel without unnecessary delay, but not later than 24 hours after the person requests appointed counsel. The magistrate shall allow the person reasonable time and opportunity to consult counsel, and, after determining whether the person is currently on bail for a separate criminal offense, assign bail if allowed by law. A record of this communication between the arrested person and the magistrate shall be made. The record shall be saved for whichever date is earlier: the date on which the pretrial hearing ends, the 91st day after the date on which the record is made for a misdemeanor charge, or the 120th day after the date on which the record is made for a felony charge. After a defendant charged with a C misdemeanor, which recall would be a fine-only offense, has been taken before a magistrate and has been positively identified by the magistrate may release the defendant without bond and order the defendant to appear at a later date in the proper court. The order must state in writing the specific date, time, and place, and the magistrate must sign it. So in other words, according to the Code of Criminal Procedure, a person arrested on a warrant for a C misdemeanor offense may be released without having to pay any bail money and instead given the date, time, and place and ordered to show up to answer to the charges. The defendant shall receive a copy of this order upon release. If the defendant fails to appear to answer to their C misdemeanor charges, the Code of Criminal Procedure states a warrant shall be issued for failure to appear, sometimes referred to as FTA. Upon arrest for that FTA, the judge may grant bail and should set the amount of bail as double that generally set for the offense for which the defendant was originally arrested. This section, in other words, all that we've just discussed regarding C misdemeanor warrants, does not apply to a defendant who has been previously convicted of a felony or previously convicted of an A or B misdemeanor. So let's say County X has issued a C misdemeanor warrant. A few weeks later, the defendant is arrested in County Z. The peace officer takes the defendant before the magistrate without unnecessary delay, and the magistrate positively identifies him. The magistrate may release the defendant without bond and order the defendant to show up at the proper court, which issued the warrant in County X at a specific date and time, and the magistrate must sign it. At this point, the defendant is given a copy of the order and released, and the information sent to the court that issued the warrant. If the defendant doesn't show up at the date, time, and place he was told to appear, then the magistrate in County X will issue a second warrant for failure to appear. Let's say the defendant is arrested again, this time on the FTA warrant in County Z. Now the Code of Criminal Procedure requires the magistrate in County Z to set the defendant's bond at double that generally set for the offense for which the defendant was arrested. As before, if the defendant is deaf or hard of hearing, an interpreter appointed by the magistrate and sworn shall interpret the warning required in a language the defendant can understand, including but not limited to sign language. If a magistrate determines a person was arrested by an officer from outside the jurisdiction in stanter, and that arrest without a warrant was made unlawfully, the magistrate will release the person from custody. If the magistrate determines the arrest was lawful, made by an officer from outside the jurisdiction, then the person is considered a fugitive from justice, and their disposition will be in accordance with CCP Section 51.13. In each case, when a person is taken before a magistrate after arrest, a record shall be made of the magistrate informing the defendant of their right to request counsel, the magistrate asking the defendant if they want to request counsel, and whether the defendant requested appointment of counsel. This record may consist of written forms or electronic recordings. Finally, if a person charged with a C or B misdemeanor appears before a magistrate in response to a summons, the magistrate shall perform the duties in this article in the same manner as if they had been brought before the magistrate by a peace officer. The magistrate shall release the defendant on personal bond except for good cause.